Everyone, I'm going to give you a minute to log in from the waiting room and get the closed caption started. I hope everyone made it through the storm okay, and I hope technology will hold out for us today with the weather being what it is. All right, the closed caption should be up. You'll see a red live box at the top of your screen, and you can click on that and it will take you to a separate screen to watch the closed captions. All right, it looks like we have a lot of people logged in already. So thank you for joining us today after the storm for Immigration Hot Topics. I'm really excited that our two speakers today could pull together all the exciting new things that are happening in the immigration world and give us this webinar today. I do want to thank the Public Interest Law section of the Florida Bar and specifically the Immigration Work Group for helping us with this webinar and getting our CLE approved. Let's see, we are going to share the PowerPoint. I've got the link to put in the chat, and there's a bunch of links within the PowerPoint for all the resources that our speakers will tell you about. And we will take questions during the webinar and also at the end, so you can type those into the Q&A box. It is being recorded, and the recording and the PowerPoint will be sent out tomorrow. And I forgot to say, I'm Christy Baglow, the Director of Statewide Training at Florida Legal Services, and I'm really happy to have with me today Adonia Simpson. She's the Director of the Family Defense Program at Americans for Immigrant Justice. And we also have Nicole Avila, who's the Pro Bono and Immigration Supervisor at Florida Legal Services. So thank you so much for being here today, ladies, and take it away.
Awesome. Thank you for having us. We're really excited. I think Nicole and I chatted that this substance could probably be a few days worth of CLE information. There's been so many updates, but we want to highlight some of the really important ones that you may encounter in your practice. We do encourage you to use the Q&A. If you do have any questions during the presentation, please put them in the Q&A. Depending on what the question is, we may be able to answer it live, or we'll save it towards the end or try to answer it through the Q&A. So please be engaged, ask the questions. We want to demystify a lot of these things. So without further ado, I want to go ahead and get started and run down some of the updates that we've seen in the last few months and break down what it actually means. So DACA, the Deferred Action for Childhood Arrivals program, has been in the news for a very long time. We all know that in 2012, President Obama rolled out this executive action, which provided a type of relief for individuals that met certain qualifications. It was not a law, it was not a statute, it was not a regulation, it was just an executive order, which essentially said that if certain people met these criteria, they could apply for deferred action, which would, the action being deferred would be removal, work authorization, and some other benefits that they could potentially get. Since it was an executive order, we did see under the previous administration an effort to rescind the program. We then saw years of litigation. It went up through the courts, the federal courts, ultimately with the Supreme Court. And the Supreme Court found that, that the termination, that the administration could terminate DACA. They just had to follow certain things with the Administrative Procedures Act. They had to go through notice and comment. They really had to go through a procedure before terminating. So the decision from SCOTUS was a victory in the sense that the program didn't end, but it did highlight how vulnerable the program is. So what we saw following the SCOTUS decision was a full re-implementation of the program. In the years that there was litigation, it was only partially active for certain individuals, but we saw the full re-implementation. So at this point, individuals who are eligible for DACA can apply. They can apply for something called advanced parole, which is the ability to travel outside the United States with permission based on circumstances. What's really important to note on DACA is there is some actual pending litigation that's ongoing in Texas. And this litigation, whereas the litigation that went up to SCOTUS was about the proper ways to terminate the program, the litigation that's ongoing in Texas is just the legality of the program in itself. And it's at the Fifth Circuit. We're still waiting for a decision on that, and it could very well terminate the program in its entirety. So we're waiting to see what happens with that. There's a lot of things happening behind the scene with the counsel for the government and the respondents, and that's happening. The litigants in that is actually the state of Texas and some other attorney generals, I believe. But the important thing is with all this litigation, the message that we should take away from it is DACA is a very vulnerable program and really subject to the whims of the administration. We do anticipate the Biden administration will try to roll out regulations, which could maybe give some additional protection to the program, make it a little bit more difficult to terminate. But with anything, you know, a subsequent administration could go through notice and comment, promulgate new regulations, and do away with the program. So ultimately, what we need, you know, after many, many decades of trying to get a DREAM Act passed, ultimately Congress does need to act and provide some sort of permanent solution and remedy. So that's an update on the litigation. Who can apply? It's back to the normal complete program. USCIS has a lot of information on their website about eligibility. A lot of legal services organizations are still helping individuals apply for DACA, so please connect them with somebody to provide legal services on this. If they've never applied for DACA in the past, they can be particularly difficult applications because you are trying to document so much physical. When it comes to processing times, just as an FYI, there for a while we were seeing applications being processed really quickly. However, in recent months, we actually have seen a huge delay, which means that we have some DACA recipients who are applying to renew their work authorization and renew their status, actually losing status because they're not being processed quickly enough, which means that they could lose their jobs because there's no automatic renewal on their work authorization if they have a pending application in process. So again, that's just the update on DACA. We don't want to go too far down the road, but I'm sure it's something that you may encounter in your practices and perhaps heard anything about. Nicole, did you have anything else to add?
No, I think you just covered it. I did drop a couple links in the chat of the current USCIS DACA page and the original memo.
Awesome, thank you. All right, temporary protected status. This is another thing that's been making a lot of headlines in recent years. Kind of similar to DACA, we'd seen an attempt by the previous administration to terminate the programs for many countries. There was a lot of litigation across the country, really focusing around the motivations behind the termination. So temporary protected status is something that exists in statute and regulations. It's the authority of the Department of Homeland Security in consultation with other agencies to grant a temporary protection. Similar to DACA, that protection is from removal and work authorization for individuals who qualify. There are eligibility requirements like DACA. There's an application process, there's filing fees, there's background checks, and there's very explicit eligibility requirements. So we saw a lot of litigation in the last few years. It was very up in the air regarding 6 of the 9 countries that had temporary protected status, whether or not the programs would end and whether or not families may have to return to home countries. There was a lot of question marks around that. Since then, we do have some updates. So we did have the addition of another country in March. As many people know, the situation in Venezuela is there's a lot of civil strife, which is a perfect example of why countries are designated temporary protected status. And we have hundreds of thousands of Venezuelans here in the US that have fled the circumstances, the political unrest in their countries. And over half of those 331,000 actually reside in the state of Florida. So what we saw happen in March was a designation for temporary protected status. We are in the 6-month period for people to register for the first time. There is a hyperlink here on this PowerPoint that you'll receive with all the eligibility requirements, the deadlines, the physical presence that you have to show, the applications that are required. We're going to talk about some of the difficulties with TPS here in a second, but I do also want to announce that temporary protected status for Haiti was announced in May, which was very exciting. This was one of the countries that was terminated. So it's been redesignated, which means that there's a whole group of additional people that are going to be eligible for temporary protected status. We have a lot more recent arrivals. As you all, I'm sure, have seen on the news, the situation in Haiti right now is very is very politically unstable with the assassination of the president today. It's been a situation that's been getting more difficult over the years. So thankfully, there is going to be this temporary protected status. Important thing to note on TPS for Haiti, we do need an announcement in the Federal Register notice. There is no application to submit. People should not be applying. Unfortunately, and I know Nicole's going to talk about this a lot, unfortunately, there's a lot of misinformation out there on immigration, and you have not just even non-attorney notarios, but sometimes attorneys providing misinformation and doing processes and applications for folks that are not appropriate. So in the case of Haiti, there is no application to submit yet, so people should just be aware of that. Once it's released in the Federal Register notice with information about where to file, how to file, that would be the time to do so. Although it doesn't really particularly impact Florida that much, we did see an announcement for Yemen and Burma regarding temporary protected status, redesignation, and designation. So there's an addition of a lot of countries, and we still have a lot of question marks regarding countries that are still in litigation. Nicaragua, Honduras, El Salvador are countries that many of whom have had temporary protected status now nearing over 2 decades since Hurricane Mitch. We do anticipate that the administration may similarly do some type of redesignation for these countries, such that they've done for Haiti. We haven't seen it happen yet, but we anticipate it happening. In regards to both Venezuelan and Haitian temporary protected status, these tend to be a little bit more complicated cases. Some folks may have some challenges. So we really do encourage a lot of applicants to seek assistance from an immigration attorney or Department of Justice accredited representative. Many individuals from Haiti and Venezuela have lived in a third country for maybe an extended period of time before coming to the United States. This creates a potential issue of what we call firm resettlement, meaning that if they received any sort of protection, residency from this third country, the US government could say, well, that country should be providing you protection and potentially deny the temporary protected status. It is the burden of the government to prove this firm resettlement, and it can be rebutted by the applicant, but it's something that there needs to be a relationship between the applicant and an attorney and a really thorough discussion and exploration about evidence to potentially rebut any allegation of firm resettlement. Also, with regards to temporary protected status for Venezuelans, we see a lot of individuals who have dual nationality, who perhaps were only way that they were able to come to the United States was to obtain a Spanish or Italian passport and entered on those passports. This is addressed by the frequently asked questions. It's not a bar. Entering dual nationality or firm resettlement is not a bar per se to temporary protected status. There are ways to overcome that, but it does require that individual attention from an immigration attorney to gather the facts and the evidence to be ready to rebut that and fight those cases. We do hope with the announcement for Haitian TPS and the Federal Register notice, advocates across the nation have been advocating that that should be addressed, the firm resettlement issue. We have many Haitians who resided in Brazil or Chile prior to coming to the United States, but there's substantial evidence that that was not actually that there wasn't any protection under the laws, that there was actually a lot of discrimination and racism, and that they should still be entitled to TPS here. So that's the state of play with TPS. An attendant issue, and I have a link here on the PowerPoint. There's a link to the frequently asked questions. That's in regards to Venezuelan TPS, but incredibly helpful. If you're doing any TPS work, please, please, please read that FAQ. It addresses the issues regarding dual citizenship and nationality. It addresses issues with firm resettlement. And actually gives some really good nuggets about processing time that you can use when you're doing inquiries with USCIS as to the adjudication of applications. So it's a gold mine. It has a lot of great information. Please use it. Also, we've seen a lot of collateral issues when it comes to temporary protected status. TPS does not have a direct pathway to US citizenship. There are some options for people who have alternative ways to apply for a green card, perhaps a family member or employment. Maybe there's another way to seek permanency through a green card, but directly TPS to citizenship, there is nothing, or to residency, there is no option. However, there's been some policy changes about these collateral ways to seek a green card. One of them is this case ZRZC. I don't know why I always want to say ZRCZ, but we included a hyperlink to the policy manual from USCIS there. Essentially, they're changing a very long-standing policy about travel on advanced parole and whether or not that travel may be perceived as an admission or parole for purposes of adjustment of status. It's something that a lot of advocates are trying to unwind and change that policy. We've also seen a lot of issues regarding jurisdiction, changes in very long time policies about jurisdiction on processing adjustment of status applications for people that have temporary protected status. So it's an area that's very much in flux. There's a lot of litigation kind of starting up and ongoing. There's a lot of different arguments that can be made. Please make sure you're reading the policy memo here. It's extremely helpful to get an idea of what the policy is of the government that many people are trying to counter. You also might have seen recently a decision from the Supreme Court, Sanchez versus Mayorkas, about TPS. The hyperlinks here. Unfortunately, there was a lot of coverage on it that was a little bit misleading. So this case resolved a circuit split as to whether TPS in and of itself, by having TPS, whether or not that was an admission or parole for purposes of adjustment of status, whether if somebody that entered without inspection and never traveled under advanced parole, was TPS that admission for purposes of seeking a green card based on a family petition or otherwise. Some circuits, the 9th and the 6th, I believe, had stated that was in fact having TPS was itself an admission, but then other circuits, including the 11th, said that it wasn't. Ultimately, the Supreme Court found that it was not an admission, so it really didn't change things for people in Florida. Unfortunately, a lot of the reporting made it seem like suddenly people with TPS are no longer eligible to get green cards. But as we mentioned, it really is about finding these alternative ways. There might be some barriers, but it still is possible. And this decision in reality did not change things for TPS recipients in Florida. And before I move on, just one more thing. A lot of partner organizations right now are working on virtual clinics for temporary protected status for Venezuelans. We actually have one starting up tomorrow for the next 3 days, and we anticipate rolling them out for Haiti. I will drop links in the chat later that you can share with applicants who may be interested in registering, but we also need volunteers. So if you're interested in learning more about TPS and some of these other more complex issues, we have a whole host of trainings for you on that. Nicole, did I miss anything?
No, I don't think so. I dropped the links for the ones that we have here. I dropped them in the chat also. On ZRZC, the date of the adoption of that decision is 8/20/2021 or 2020. I'm sorry, and it's so anybody who traveled on advanced parole after that date is not going to be eligible to adjust status based on that advanced parole if they had a previous entry without inspection. So just, a caution to make sure to reconcile your TPS cases with ZRZC before filing adjustment or when evaluating for adjustment.
Absolutely. I'm really glad that you brought that up, because I think a lot of people have misinterpreted, like, across the board, AP travel doesn't qualify, but if it was prior to that date, you should have no issues. But also make sure that you're potentially doing FOIA's, Freedom of Information Acts, on your clients. A lot of individuals, particularly Haitians, have been through the immigration court process and may actually have an outstanding final order of removal, which could play into this jurisdictional issue as to who has jurisdiction to adjudicate the case. So I feel like that's like advanced TPS adjustment issues. So we'll leave it at that. And then shortly I'll share the links for the clinic. And then finally, I just wanted to address one thing. You may have heard a lot about a public charge rule. One of the most confusing things ever, similar to DACA and TPS decisions by the past administration, there was a promulgation of some regulations and then subsequent litigation and a lot of things happening on that changed the test as to whether or not somebody was going to be deemed a public charge when they were seeking admission into the country or seeking a green card. It does not, this whole test does not apply to a lot of people. A lot of people are exempt from it, and it doesn't apply to people that are naturalizing. Essentially, after litigation, the rule has reverted back to the 1999 version. So I don't want to get into what the rule was and then what it went back to. Essentially, it's as whether or not immigrants receive certain public benefits, which are very, very limited, that actually most immigrants are not eligible for, could potentially be determined to be a public charge and not eligible to get a green card. Most immigrants are not eligible for benefits. Those who are eligible for benefits are normally, like 99% of the time, exempt from a public charge finding. It does not apply to U.S. citizen family members that are getting benefits. So the reason I bring this up is this rule has been particularly problematic during the pandemic. We've seen scores and scores of clients unenroll their children from benefits to which they are entitled, or not seeking benefits to which families are entitled, for fear that they may have issues with immigration, that immigration applications will be denied. That's false. So really, the one thing on public charge, I don't want to talk about really what it is necessarily, but it really doesn't apply to most people. So you should, if you encounter people that have concerns about getting public benefits for their family members, or applying for any of the emergency benefits or assistance that we've seen in the pandemic, or receiving any stimulus funds or anything like that, please encourage them that it is okay, that it will not impact their immigration status. If they are green card holders seeking to naturalize and they're eligible for benefits, please, please, please take the benefits that you need. So that's the most important thing. This too could be an 1.5-hour seminar on public charge. But anyways, it's back to the 1999 version, but the damage has been done. There's been such incredible misinformation on this and a lot of fear. So if you can help us dispel some of that fear and make sure people are getting the benefits to which they're entitled.
Okay, so we've had some exciting updates also regarding humanitarian forms of relief. So we're going to go over the new updates on the bona fide determination for U visas, and some changes in after acquired spouses for U and T visas. So the bona fide determination, that was a policy alert that was released by USCIS on the 14th of last month. And the purpose of that is essentially to make the process go a little bit faster. Right now, we're looking at about 5 years to join the U visa waitlist, and somewhere around 15 years to have a U visa granted, since there's well over 150,000 visas pending and only 10,000 available each year. So in an effort to alleviate that backlog and provide a benefit to the survivors of those qualified crimes before those 5 years, they developed this bona fide determination, which is allowed under the law and the regulations. And if, Adonia, can you click on the process hyperlink briefly? So they did do this handy chart for us that's in the appendices of their announcement. So if you see here, they're going to go through the U visa application to make sure that it's bona fide. That means that you have everything you need for an initial application, that the person did a statement that is signed. They're not going to go over inadmissibility issues at this stage. So if the person needs a waiver for anything other than EOIR or unlawful presence, they may not be eligible for the bona fide determination. If they're not eligible, they're going to go into the waiting list process, which is what we've seen historically, that right now takes 5 to 6 years. If the person is eligible for bona fide determination and there's already an application for an employment authorization document pending that you sent along with your U visa, they'll just send the EAD card to you if they're eligible, and it'll have a validity of 4 years. Okay, and it comes with deferred action, meaning, again, like Adonia said, the action is removal, and so they will not be removed potentially. They are going to be reviewing their record periodically during those 4 years. So, if they ever fall out of eligibility, they may not have that benefit any longer. So, if the person doesn't qualify for the bona fide determination, it doesn't mean that they don't qualify for the U visa. It just means they need to go through the application a little bit more closely. And so they'll go into the waiting list and have that more thorough adjudication at that time. Because like I said, they're not going to go through waivers and adjudicating waivers at this stage. It's just meant to be something to give the survivors a way to work and have some stability while the case is pending. And presumably it'll be renewable until they're able to get their U visa.
Now, Nicole, I have a question for you from the Q&A. Is there any word on the time frame for these bona fide determination EADs? Has CIS given information?
So I did see someone receive their first one yesterday, and their application date was October 2016, and they received a 4-year EAD. So it looks like they are starting to process these already. So the idea is that whoever is, they're working from the timeframes in the same order in which they were set. So it looks like somewhere around 2016 might be receiving that benefit now. And then I'll just highlight, because I don't think I said it before, once you get that BFD determination and you get your work permit, you're going to go back into the queue, and it's just going to be that basically chronological adjudication unless you have some grounds to expedite that application.
So then, to summarize, if somebody recently filed a U, perhaps in the last year, it might be a little bit before they get that BFD.
Correct. And I think, and this is just total conjecture, my guess would be probably 1 to 2 years. And that's just from presuming that it's going to be less than 5.
And one more question before we jump on. And this is a really great question because I've gotten this a lot. So folks that maybe didn't submit the 765 work authorization with the initial U visa application, do you wait for the BFD? Do you file now? What do you do?
Please don't file now. So the USCIS announcement and the entire everything that they gave us so far about this benefit states specifically that please don't file any I-865s if you didn't do it yet. They will be sending you a letter telling your client that they're eligible for the BFD, and then at that point you can submit your I-765. Submitting it beforehand will probably just delay things for your client. There's a possibility it might not even make it to the file, so it don't send any floating I-865 or I'm sorry I-765s until you get that letter. And then so on Medina Tovar versus Sochowski, that's a 9th Circuit case that found that after acquired spouses for U applicants, that the period that we're going to look at is is until approval rather than from filing. So meaning that if the survivor applies for the U visa and marries before approval, that spouse can be included in that U visa application. USCIS has now adopted this for nationwide application, and they've said that that when they're confirming the relationship between the principal and the qualifying relative, based on marriage, they will evaluate whether the relationship existed at the time the principal petition was favorably adjudicated and not when it was filed. So this means all these folks that I think for years we've been telling people, okay, get married and then we'll file your petition. So we don't have to do that anymore. And it applies also to T visas, which is a really great update in my opinion, because we don't have the benefit of an I-929 in T visas as we do in U visas. So we're able to include those after acquired spouses up until the time that, as long as they married before it was adjudicated. So at that point, even if we get the adjudication but they married before, we can still file that I-914A for that after acquired spouse. So it's great news all around for T and U applicants. And then some updates on the immigration court and some of the cases that I think were the bane of our existence over the last few years. Matter of AB was the case that kind of got rid of decades of jurisprudence regarding domestic violence survivors whose asylums were based on domestic violence in home country. So now that has been vacated, which means we go back in general to what the law was prior to AB, which the case that was seminal in that regard was matter of ARCG. It's always going to be on a case-by-case basis, and of course depend on the judge that you're in front of, but it's a great advancement in this regard because they can't just deny outright like they were doing under matter of AB, which expanded it expanded the ways in which to deny the case by narrowing the scope of the law. And it had some terrible dicta in there about unable and unwilling to control and what that meant. So we're back to what the law was prior, which made a lot more sense, and it's a great advancement for folks who are fleeing domestic violence in home country. Similarly, matter of LEA is a case that talked about asylum based on nuclear family nexus. So only LEA 2 was vacated. LEA 1 is still in place, which means that you still need that double nexus. So you need nexus to the family and you need nexus to a protected category. But it's still great law, especially for those folks who have that connection to that nuclear family, which we can continue to argue now. On dedicated dockets, we don't have a ton of information yet. There are some engagements that are continuing to happen from the White House. In essence, they are putting cases related to their asylum cases, and they're going to be dealt with within, I think 365 days is the goal.
I think they're actually doing 300 days, and it's for people that entered between ports of entry following the date of the announcement. And it's only impacting 10 jurisdictions nationwide, which of course one of those is Miami. And we do anticipate that there's going to be a huge need for pro bono services. It's going to be a lot of work on legal services providers to try to ensure that folks are adequately represented. One of the concerns, and one of the concerns that was expressed by both DOJ and DHS on these calls, is that it's not supposed to be like pocket dockets, that they will be liberal in granting continuances where appropriate. With that being said, there's always a lot of discussion when it comes to judges on how they may treat these cases. So it's still a little bit to be determined. We're waiting for more information, but we do anticipate that there's going to be a huge need in our communities for removal defense representation. But going back to what Nicole said, the decisions, these vacatures on AB and LEA, really do open a lot of doors for people that may not have had some options previously. So that's the dedicated docket.
Yep. And then on the EOIR Courts and Appeals System, which is the online filing system, I know that they're deploying in stages. It looks like let me take a look at the list. I think it's all or most sites at this point. So DHS can file the notice to appear and any court documents. We can file our notices of appearance online, and we can view and download electronic records and pay fees, it looks like. So I know that they've been working on this for a while. I'm not actually very familiar with whether it's working well or not in our jurisdiction, so I'll defer to you on that.
So it just went live for Miami on the 24th of June. And I want to say the week or two before at Chrome, and then a few months before that in Orlando. The thing that you kind of find out when you do the training that's a little disappointing is the ECAS just applies to cases that are filed, that the NTA is filed after it's launched. So if you have a case that's been around for a couple of years, the electronic ROP and electronic filing, unfortunately, will not be available for you. But if it's a new case that's filed, there is ways to, it's moving towards electronic filing, which is pretty phenomenal. But it's going to be the newer cases. So any of those old lingering cases that you have, you'll still need to file the old way with EOIR and potentially e-service with OPLA. So we are excited that it's rolling out. I mean, it is, it's long overdue that we have a system that's a little bit more advanced. So we are looking forward to it, but I do anticipate some hiccups with the rollout, but it is live officially at all the courts in Florida.
Yep. Hearings, I know that Miami's going forward on hearings already. And I'm not sure about Orlando. Let me take a look. But I think all of our courts are going forward on hearings at this point with regards to prior COVID restrictions.
So for Miami, as of right now, master calendars are still being continued. We're waiting for news about what their plans are for August and beyond. In regards to individual hearings, we have been told that they're doing a rotation of 2 judges that are on 2 teams of judges, for individual hearings. So we do anticipate, having more individual hearings going forward. EOIR, because of security concerns, will not be sharing the information as to the teams and what judges are on for a certain week. So unfortunately, and this has been a concern that's been raised by a lot of organizations as far as communication, as far as not finding out until the day before your hearing that it's not going forward. You filed a motion to continue and it's not rolled on until the 11th hour. And it's putting a lot of, attorneys in this situation where you do need to prepare and meet the filing deadlines and prepare as if your case is moving forward, understanding that it could be potentially.
So prosecutorial discretion is another piece of amazing news. So we had great prosecutorial discretion and requests and relationships with the ICE attorneys back in 2014. And that was completely gone through the last few years. So ICE has released new priority memos, and they have 3 presumed priorities, which are national security risks, folks that pose a threat to the public safety and have an aggravated felony conviction, and recent border entries or entries without inspection, and that means post November 1st, 2020. So but they are still going to review on a case-by-case basis. I know in Miami, they have said they don't have any blanket, they don't have any sort of blanket, we're going to grant PD to all of these particular cases. Are just going to evaluate on a case-by-case basis. As attorneys, we have to e-file those requests in the e-filing system rather than using the PD email address that was initially sent out pro se folks can still use that email address. And the secretary did say to, or the ICE director did say to please request early as possible in the process. And I know that some ICE attorneys have reached out to defense attorneys to say, I know we have this case coming up in court. We are prepared to offer that, a dismissal, or it just depends on the case. But that is a very welcome change from how the ICE attorneys were operating in the last few years. So we do encourage everybody to review that memo very closely, show any of the positive factors, as many as you have, and humanitarian factors in your clients' cases. Don't hide the ball on the negative factors, but just be mindful of what you have to show, and what, with the caveat that ICE has said that they can use what you are sending to them in case that PD request is denied later on in court. So be mindful of what you send, but don't hide the ball on those negative factors. They're obviously going to have biometrics on file and check your client's background. So usually just kind of take the wind out of their sails and explain why the things happened.
And my one tip on, please read the OPLA memo. There's a lot of really great nuggets in there. I think it's important to keep in mind that prosecutorial discretion can mean a lot of different things. In the ICE memo, generally it addresses whether, NTAs should be filed at all and things like that. So there's a lot of advocacy that you can be doing with your clients prior to them being put in removal proceedings. But once removal proceedings, I think the one big difference, and this is based on the BIA, the Castro decision as far as administrative closure, whereas under previous PD, ACing, administrative closing the case was the resolution we were getting. In our jurisdiction now, it's dismissal. So one thing to consider is if you have a respondent, a client in removal proceedings, does it actually behoove you to dismiss the case? Is their work authorization predicated on a pending application for relief, whether it's cancellation or asylum? Would dismissing the case then cut off their eligibility for that? And then also, taking into consideration the likelihood of the merits, of the success on the merits of the case. Is this a winnable case? If it is, go forward, because there's other nuggets in the OPLA memo, asking OPLA to stipulate, asking them, it can happen. Ask for a stipulation to a grant of relief, or at the very least stipulating to certain elements of eligibility. You don't know unless you ask. So it's definitely worthwhile. Another piece of a little nugget in the memo, given that whole discussion we were having earlier around temporary protected status, there is it explicitly says somebody that's prima facie eligible for TPS would be potentially eligible for dismissal of a case. So many of these individuals who have maybe not the greatest asylum case from Venezuela or Haiti, this could be a great option for them, and they would have temporary protected status in the interim. But you have that conversation to see about, there may, just because your client is eligible for prosecutorial discretion, is it actually the best option? But do spend some time on the memo. It's not that long, but there's a lot of really helpful things in there. And then also read the ICE memo too, because there's a lot of advocacy that you can be doing, before your client gets into removal proceedings, options to make sure that NTA is not filed at all, right?
Absolutely. There's some really great language in both the ICE memo and the OPLA memo on what the presumed priorities are, and I know that I was working on one recently, and they have just some amazing language that you can really hang your argument to. And I will caution folks regarding stipulations. There's BIA case law that says they're not really binding on the BIA, so definitely have those conversations, and just with the understanding that you might still have to put on evidence or testimony in court to address those points if you're going forward on the case, because the BIA won't just rely on what OPLA agreed to or stipulated to.
Yeah, and one last thing regarding prosecutorial discretion, and we didn't put a link to this. I don't know, Nicole, if you can access this link to the EOIR PM about it. So following OPLA putting out their memo, EOIR, the immigration courts, actually put out a memo which really instructed the judges to make an inquiry as to whether or not there'd been discussion, whether or not OPLA had looked into prosecutorial discretion or was considering it, and just really making that inquiry. And I think, you know, encouraging the courts to be somewhat lenient to let these things happen, let respondents explore this as an avenue, which means continuances to potentially do this. So there is this attendant PD, I don't want to say PD memo for EOIR because it has to be the prosecutors, it has to be OPLA that gives PD, but it does encourage EOIR to make sure that these conversations are happening.
And I do think part of that memo is that EOIR is encouraged to ask OPLA whether the person is a presumed priority as well. So that's, I think, a great tool for us to get that on the record as well when we have an attorney that perhaps isn't so amenable to PD. But they, I know that the ICE director or the OPLA director did mention several times at one of the engagements that they are really encouraging folks on the ground to grant PD where it's advisable on their end. And so definitely start trying it. I have heard of several folks who have gotten calls from OPLA offering, you know, dismissal or different forms of PD, and folks requesting PD affirmatively as well that have gotten great results in all jurisdictions. So definitely back.
Yeah, and our office has gotten some, so we're excited to see it moving forward. You know, again, just because PD is being offered is it necessarily the best thing. So we had some other hyperlinks here of additional resources. The ILRC put out a really great practice guide on prosecutorial discretion. Another practice alert regarding after acquired spouses. Which, speaking of, in the Q&A, Nicole, we did have a question that I'm hoping you can answer. It's in regards to this. For the marriage analysis, does the U recipient have to be an LPR, or can he be a U.S. citizen who is married prior to the U adjudication?
That's a very interesting question. I'm going to have to look into that and get back to this person. So if you want to drop your email in the chat, I'll be happy to look into this and send it, and I'll send it to Christy also so she can send that answer with the materials. In the U context, though, you always have the I-929 before adjustment. So you do have that option as well. I'm not entirely sure whether you can still get that up through the point of U.S. citizenship.
I think it cuts off the U.S. citizenship because you're no longer a derivative. Don't hold me to that, but
yeah. And at that point, you would have, I mean, obviously there's going to be concerns because the U waivers are so much more expansive, but you do have the family petition option as well. So I think those folks will have other options, and this is intended to cover those folks that might not. You know, we have lots of clients that tend to marry other undocumented folks, and so it's intended to that. And even for the I-929, you know, you're at the point that you cease being a U1, the things change for those folks, and so the process is a little bit different. So I don't know the answer for sure, but I suspect it's not going to cover those folks, and you would just have to access the family petition forms of relief to get that person's status.
Well, those were all the Q&A questions. Again, if you all have questions, please put them in the Q&A. Christy?
Thank you both so much for such a good overview and the practice tips. It's good to hear good news about immigration for a change. Those are really nice to hear. So I really appreciate all the links you guys put in the chat. And I'll send out the link to the PowerPoint and the recording tomorrow. as well as the CLE certificate. I did want to announce the CLE number. It's 5310. Again, it's 5310, and it's been approved for 1 general CLE credit and 1 immigration and nationality law credit. So thank you so much, Adonia and Nicole, for putting this together on such short notice and disseminating all this great information to us. All right, I don't see any other questions, so I will let you all go. Have a great afternoon, everybody.
Bye. Thank you.
Bye.
Thank you.